Welcome, friends, to the Probate Nation, especially you viewers from the great state of South Dakota, where they have the Black Hills National Forest, Mount Rushmore, and Crazy Horse Memorial. My name is Richard Ruddy. Tonight we will learn the basics of probating a South Dakota estate, from where to begin your probate journey, the legal and tax stops you will need to make along the way, and when to deliver the estate to the beneficiaries. You know, probate is very much like traveling on a slow-moving steam engine train, which calls to mind the train trip many years ago of a famous U.S. Supreme Court Justice Oliver Wendell Holmes. When approached by the conductor who was confirming passenger tickets, Justice Holmes could not find his ticket. The conductor, recognizing who he was, said that would not be a problem, but as justices are apt to do, Justice Holmes dissented. And while he had purchased the ticket, he really needed to know where he was going. So we're fortunate to have with us tonight Jared Tomac, a South Dakota probate attorney who knows all about South Dakota probate. He will share critical steps to be addressed and stops to be made in the course of any probate journey. But first, let me tell you about Jared. Jared and his wife Jennifer are often described as the husband and wife attorney team. Each of them worked for a number of years for the Fairfax Commissioner of Accounts, the office that oversees probates in Fairfax County, Virginia. Jennifer as a staff attorney and Jared as an auditor while he was attending law school. Jennifer started her own law practice in Virginia, and Jared joined her shortly after graduating from law school, and in 2015 they made the decision to return home to South Dakota, where they opened a law practice in Rapid City, South Dakota. Their practice concentrates on estate planning and asset protection planning, elder law, guardianships, conservatorships, and probate. When they're not helping clients, they're busy raising 4 boys from college age to elementary school, getting them to and from church, various sports, rodeo, and all other things that kids from 10 to 20 do in South Dakota. Jared, welcome to see you again. Nice to have you back on the program.
Thanks, Richard. It's good to be here.
I really thank you so much for sharing this time with us on the Probate Nation, family, across the country. And so before we jump into this topic, what with all the YouTube videos out there on just about every topic under the sun, so many folks like to do things themselves these days. Is South Dakota probate something a person can do on their own, and I say that pro se, without an attorney?
Well, there isn't anything legally that would prevent somebody from doing that. The problem is that there aren't forms. There's nothing that would make it easy for somebody to be able to practically get in front of the court and explain the things that they need to explain to the judge or to the clerk to order to open up that probate. So not legally prohibited from an attorney not being involved, but it's really impractical.
Okay, well, that's good to know, and I think that's helpful for folks to keep in mind that as we go and have our discussion today, what we're really doing is kind of laying out kind of the basics so they can understand that what the game plan is going to be when they go to see an attorney for assistance. So let's go ahead and turn our attention now to the first part of this process, which is, let's talk a little bit about what court, let's just start with that. What court oversees South Dakota probates?
Sure. Our system doesn't have a specialized court for probate. It is the general court of record within South Dakota, which would be our circuit court. And we don't have any specific judges who oversee specific probate matters. We're small enough in South Dakota that the judges get what comes before them, whether it's criminal or a divorce or a probate matter. Essentially, once the case is filed, you get the next judge up on the list.
Okay, so you guys are basically, all those judges are general practitioners, it sounds like.
Yes, they are.
So I understand from our discussion in preparing for this show that there are different options available to probate estates in South Dakota. So just tell me a little bit, what are those 4 options? And then we'll get into the details in a second.
Sure. Well, at the very base level, we have the option for a small estate affidavit. The legislature has understood that probate can be very expensive, time-consuming. So there's an option available for small estates. Then we have the regular probate itself can have 3 different functions. One is an informal probate. Secondly, there can be a formal probate. And thirdly, there can be a supervised probate for those situations that require a little bit of extra supervision.
Okay, so I understand that which probate we would actually end up with in order to take care of an estate is not determined whether you have a will or not. So I think that's important to know. But
That's correct.
In preparing for this show, though, I think I wanted to ask you about, because I think you mentioned at the outset, a lot of states have forms online and so on at their local court or statewide that people can use to basically do these probates themselves. Are such forms available to the public?
There's nothing in South Dakota available to the public for those type of forms. I believe that there are some general ones when people can search online and find something similar. We're part of the UPC, which is the Uniform Probate Code, so we are similar to some other jurisdictions, but there's nothing South Dakota specific.
Okay. So let's go ahead. I think the analysis, we have kind of the framework of what kind of probates are available. Let's go ahead and take a look at, probates can be either with a will or without a will. So I want to go first with, probate with a will. Where do folks typically, in your experience, keep their wills in South Dakota?
Yeah, we have a lot of different places. Folks out here very often will keep them at home, in a file cabinet, in their fireproof safe, whatever it may be. Often against attorney advice, folks have them in a safety deposit box at the bank or the local credit union. Sometimes the drafting attorney might have them in a will bank, or they can also be filed with the local circuit court. The problem with filing with the local circuit court is it's kind of a historical practice that used to be more popular, and a lot of the courts aren't accepting wills pre the testator having deceased. Okay,
so I know you mentioned a safety deposit box, and I found it very interesting when we were preparing for the show, how difficult or how do you go about getting that will out of the safety deposit box, even if you know it's there? Okay, how do you go about getting it?
It gets a little tricky, and it depends on where the safety deposit box is housed. We have a banking code that allows for a bank individual to enter the safety deposit box to determine if there are testamentary documents in there, like a will or a codicil or a trust. The problem is that the person to whom is named as the personal representative or perhaps the successor trustee can't go in and look. We have to rely on the bank to do it, and in their determination whether it's a testamentary document or not. And it even gets a little trickier with credit unions. Credit unions don't fall under the same banking code that our banks do, so they basically get to write their own rules about who they let in and when. And most often, you end up having to go to court to get a court order to show the credit union, yes, we need to get into this box to get the will that we believe is in there.
Okay, well, that sounds like it's challenging. So, so whatever the will might be, whether it's a formal written will or whether it's a holographic will, or is there a requirement to submit the will to the court within a certain period of time?
Yes, it has to be submitted within a reasonable period of time, but that's as far as the code goes in defining it. As long as someone is taking the efforts and steps and they're not being dilatory, the court's going to determine that to be reasonable. But they really want it to get started within the first 3 years after someone passes away. So you hear that sometimes locally in as a deadline, you've got to get started with the probate process within 3 years.
Okay, let's sort of switch gears and talk about probating in a state where there's no will, which is referred to as being intestate. So if there is no will, okay, are the probate options pretty much the same as with the will?
They're very similar.
Okay.
The only thing that changes is the name of the personal representative can either be, it goes from executor to administrator. We generally like to use the term personal representative because it encompasses both. But all of the options, such as a small estate affidavit or informal, formal, or supervised probate, are available whether there's a will or not.
Okay. And then intestate basically means that the state of South Dakota has written your will for you. So I know there's some kind of quirks there that can occur depending on second marriages. So I think people need to be aware of that. You want to mention that?
There's a very specific requirement in South Dakota that if there's a blended family, let's say the decedent was previously married or not even previously married, just had children from a prior relationship than the current spouse. When that decedent dies, the current spouse is going to get the first $100,000 of the entire estate, and then the remaining $100,000 will be split amongst children, all of the decedent's children. So they could have been from the first relationship or the second relationship. They're going to share 50% with the spouse.
Okay, well, that's good to know, and you want to make sure that was your wishes. Otherwise, you ought to get a will prepared, right?
Absolutely.
Let's talk about the different probates. So let's talk about small estates. And I don't want to spend too much time on this, but I think what qualifies for a small estate?
Yep. Small estate in South Dakota is less than $50,000. And what varies from other states is we always have to consider the real property. So if you owned real property, it's unlikely that a small estate affidavit would be available to probate your estate, but it's something to keep in mind because it's a far easier and quicker process than going through regular probate.
And the way, as I understand it, which is sort of similar to other states, is that you basically don't really have to do any filings with the court, but you rely on a small estate affidavit to go recover the assets, and then you take on the responsibility of doing stuff with that money.
That's correct. One thing we like to explain to our clients when we do this for them is we'll draft that affidavit for the client. They can then go present it to the asset holder, whether that's a bank, somebody who owed the decedent money. But at that point, then that individual who has received those assets is responsible for ensuring that they go to where they're supposed to go.
Okay. All right, let's jump ahead. So I know we talked about regular probate, and it kind of breaks down into three branches. Okay, so let's talk about the one that's most common, which I gather is the informal probate, which you had mentioned. So tell me, what is an informal probate? How do we fit into that particular bucket as far as probate?
Yep. It's kind of the general process that you would normally think of for probate, where someone gets appointed to become the personal representative, and then they have the ability to marshal assets and pay expenses and ultimately pay proceeds of the estate to where they belong. The difference in informal probate is that it's exactly that, informal. We submit a petition to the circuit court clerk. It doesn't actually make it to a judge if it's informal. The clerk will review the petition, and if there's a will, the accompanying document to go along with the petition, for the formalities and the appropriate requirements for probating that. And if those are all met, then the clerk will grant probate and send letters of administration and the order back to the personal representative or the attorney if we're doing it for them. It takes out a lot of that time and the necessity to have to go to court if everybody's in agreement anyway and everything looks good. The court will very often, or the clerks will very often allow that to happen. Okay,
so let's jump to the next level up, which I gather in the regular probate is called the formal probate. So, you know, what estates normally get put through the formal probate process?
So a formal probate, it's really anything that can't be informally probated. And some of the things that are required for informal probate would be if you have an abnormally signed will. And by abnormally signed, it could be holographic, which is a totally valid will, but it just needs a little bit more proof.
Okay.
So a holographic will would have to go through formal probate. Or if your will wasn't self-proved. Self-proving affidavit is where you have two witnesses who will sign that will and verify that this is what it is. If you don't have that self-proving affidavit on the will, then perhaps the witnesses to the will likely have to come in and testify that this is the document that they saw signed 3 years ago when the decedent signed it. But we have to get that oral testimony, so we're going to need formal probate in that circumstance. The other circumstance would be if we don't have a will and someone who has the same level of priority to serve as the personal representative in an intestate estate, if they're not willing to waive that right and appoint somebody else, then we'll come into the court and the court will take the evidence and determine who should be the personal representative.
Okay. Now, I know there's some other details here. So typically with if there's a will, frequently bond will be waived or surety on the bond will be waived. But if there's no will, then we're at the mercy of the court to make the decision?
We can be, yes. Bond can be waived by the other affected beneficiaries. So if all of the beneficiaries are willing to waive that bond requirement, that can be something that can be done. But the court also has their own authority on their own to be able to say, really, in this instance, having a bond is not in the best interest of the estate, so we're going to waive it.
Okay. And the last, I guess, the highest level of probate is called a supervised probate. And I know we won't talk about all the nuances in there. We're going to come to that in a second. But what estates normally get put into that particular bucket?
This is the one where you may have some folks who don't get along well. This is where you've got somebody, because now remember, we've gone through the process and either the clerk has looked at the personal representative and determined that they're appropriate, or a judge has looked at the personal representative and determined they're appropriate. But even if that happens, oftentimes families don't agree that they're appropriate. This is where a beneficiary or someone else concerned in the estate could assert their rights and say, no, court, we want this to be supervised. We don't believe that the personal representative is going to do X, Y, and Z appropriately. We want the court to have to order before they can cut a check. We want the court to have to issue an order before they can lease out property, before they can hire an appraiser. All sort of things that a personal representative has to do in establishing the estate. Well, now the court has to sign off before they do them.
Well, that's important to know, because I think we do have those arise, and of course there's costs that go with that too. So people have to understand that.
Absolutely.
Now, before I want to jump into all the various duties, identification of the heirs. Okay, if I have a will or I have an intestate with no will, I got to give this stuff to somebody. Okay, so how do I go ahead, if I'm not related to the family, how do I go ahead and figure out who's supposed to get it, and identify them so I can deliver it to them?
Absolutely. So as long as you're making reasonable investigative efforts, the court's going to approve what you're doing to conduct the search. But obviously, going to family and friends is the absolute natural way at which you identify who might be associated with this estate. And 90% of the time, that's where you're going to get most of your information. Other friends, other people who knew the decedent, those are the closest connections that we can have. We've had some folks have some success with social media. In fact, we've done that on our own, where we've been able to figure out some family trees by chasing down social media. You can put an ad in the newspaper. There are some third-party search firms to help find relatives. But most of the time, we're a pretty tight-knit community here in South Dakota, and somebody usually knows somebody who knew so-and-so's nephew, and we can try to track that down through the grapevine. Okay,
Jared, I think now what I'd like to do is to turn our attention to just talk about some of the, whether you're informal or formal or supervised, what are some of the duties that a personal representative needs to undertake, will have to undertake?
Sure. A personal representative in South Dakota is a fiduciary, so they have fiduciary duties to the estate, and that means that they have to marshal the assets. They have to understand what the debts and expenses of the estate are. They need to obtain a EIN, an employee identification number or a tax identification number, and they need to take care of the assets of the estate as if they were caring for someone else's money, because in fact they are.
And so, and then most probates, at some level may have to file an inventory with their opening entry of assets, and then maybe have to file an accounting showing what they received, what they dispersed. Do all of these accountings have to do that, or is it only in certain situations?
Only certain situations. South Dakota kind of has a unique inventory statute, and an inventory is required to be created, and the fiduciary must create that, but they don't necessarily have to file it unless someone has asked for it.
Okay.
And even then, they don't have to file it, they just have to give it to them. And in accounting, they have to know what's happened with all the money, they have to have good records for that, but that accounting doesn't always have to be filed because it's very often waived by the beneficiaries and heirs of the estate.
Okay. And then Anything special we have to worry about as far as handling real estate? Do we have to go to court to get anything done particularly?
Real estate becomes part of the estate. If a decedent owned it in their individual name, it becomes part of the estate. There's no special authority to do anything with it. The personal representative automatically has the authority to sell that real estate if it's in the will, unless their order of appointment says otherwise. Beneficiary could assert something at the very beginning, but unless that's done, the personal representative has the authority to sell.
Okay, and so let's switch gears now. We've collected all the money, filed our stuff, but obviously we got to make sure we pay all of our bills. So I know this becomes challenging between known and unknown creditors. How do we go about getting that cleared out so that we can get to the point where we can actually distribute the estate? I know we talked about some notices or publications. Can you just summarize that for us, please? Absolutely.
So if we know of a creditor, we specifically send them notice. We send them a letter that says, we're going to give you, you have 60 days to file a claim to assert your claim against the estate. But like you said, we don't always know who the creditors are. So we publish in the newspaper for 3 consecutive weeks in a newspaper of publication in the area where the decedent passed away, saying, this estate is open. If you have a claim, now's the time to bring it. And that period is open for 4 months. And if the creditor doesn't file their claim within that 4-month period, they may be disallowed.
That's good. That's very important. I think it's important to do. So I'm going to switch gears and go one further. We've taken care of creditors. The process to wrap up the estate and actually give these beneficiaries their money. What do we have to do?
Absolutely. Again, it varies on the type of probate that you're in. If you're an informal probate, very often what ends up happening is we file what's called a verified statement of closing. You walk through the process, you distribute the money the way you're supposed to, and then you file a verified statement indicating to the court that everybody received the assets they're supposed to, and you send notice to all the beneficiaries. And then it remains open for 1 year without any action being taken. The estate closes a year after this verified statement of closing. If you want to close a little more formally, which is generally what we do in my office, because I like to have that order that says you are done today, is we file a petition that says, court, here's what we did. Here are the final distributions we want to make. Please approve these distributions, approve my attorney's fee, approve the personal representative fee, and close and discharge my responsibility as a personal representative today.
Okay, I think it's wise to go ahead and get that if you can. Okay, I'm going to go ahead and switch gears back here as we come to sort of the wrapping up of this particular show. And you know, there's lessons learned that obviously I'd like you to share because you had a lot of experience probating stuff. Could you go ahead and give us the benefit of that for our viewers?
Absolutely. I think one of the greatest lessons learned that I've had in my years of doing this is there are processes in the system for a reason. And if you fit within the processes, great. And always go more formal if you have any concerns. If there's a beneficiary who it's just something in the back of your head isn't quite right, or we have a concern with a creditor, or you thought maybe there were some other assets out there, but you just can't find them, take a step up. If you're at informal, it's okay to go to formal. If you're at formal, it's okay to go to supervised. And because most of the time when I'm doing this, I'm representing the personal representative themselves, and I want to make sure that they're covered. And the more formal you go in the process, the more coverage you have. And that's really the lesson that I've taken away for enough clients, that it's okay to go through the more formal process, even if an easier avenue exists.
You know, Jared, I'm sorry that we are constrained by time. There's so much more I know you could add, but I appreciate you so much on behalf of the Probate Nation for visiting with us, you know, for sharing an overview of South Dakota probate law, your advice as to what to do and not to do if probate's necessary, and the need to have a South Dakota attorney handle the details of probate during the course of this journey. It's really valuable information and a great public service to our viewers of the Probate Nation in South Dakota. So I want to thank you again for taking the time.
Absolutely. It was my pleasure, Richard. I had a good time.
Good to see you again, too.
You too.
You know, without a doubt, probate can be complicated and confusing. Jared has giving you an excellent introduction to the South Dakota probate process, including steps to take and pitfalls to avoid. But I would be remiss if I did not note and emphasize that there are many legal documents to be drafted for even an informal probate. And none of these are standard documents posted online for you to undertake a do-it-yourself probate. You really need an attorney to handle the probate for you. Their guidance will help you avoid unnecessary work, delays in your probate journey, and additional fees and costs will be saved. Friends, this brings us to the conclusion of our show. I hope you found it helpful. On behalf of the Probate Nation, thank you for visiting with us. We look forward to seeing you next time.